And secondly, we have updated the list of exhibits. I've provided my colleagues with the updated list.
Thanks.
The only thing that's new, my lord, it's at number 87 on page 7.
87.
Yes. Number 87 on page 7.
Okay.
Exhibit XX.
Yeah.
That's the SAP 310 form
Okay.
regarding interview with the suspect. It's a form that was handed by Adv Mngomezulu.
It was handed to you by Mr. Mnisi.
Yes.
Right.
At the request of Advocate Nisi.
He says he wants to use it.
Yeah, well, he requested that it be handed up. I suppose he's going to be fair.
Oh, here explain.
Yeah,
Okay, fine.
at some later stage.
All right.
Then number 88 on page 8.
Yes.
It's exhibit YY.
Right.
This is a letter from Legal Practice Council dated 5 May 2020 confirming the enrollment of Mr. Dominic Mngomezulu as a legal practitioner, which was received by Brigadier Gininda from Mr. Mngomezulu at Pretoria North Police Station
Yeah.
on the 23rd of June 2020.
Okay.
It was handed up via Brigadier Gininda.
Gininda. Okay.
Thirdly, my lord, when we adjourned the proceedings,
Yeah.
Brigadier Gininda was under cross-examination by Advocate Mngomezulu, and the further cross-examination stood down at the request of Advocate Mngomezulu.
Okay.
Lushushisilana bekachaza ukuthi kunamaphepha asanda kwakhona ukuthi kunezinto ezithize ezishintshile la ukuthi kunobufakazi buka XX kuneform eyukuthi bekade kukhulunywa nabamangalelwa bese kuba nobufakazi buka YY ekuyincwadi eyukuthi yasho ukuthi uDominic Mngomezulu ngempela ungummeli eyukuthi basazokhuluma ngayo. Enye into futhi uma sigcina nyakenye ummeli uMnumzana Mngomezulu wayekade esabuza uBrigadier Gininda imibuzo uzoqhubeka kusukela lapho.
Okay, where is the brigadier?
It's just outside.
Oh, okay. For record purposes, Mr. Mngomezulu, have you recovered or recuperated from your ailments?
That is correct, my lord.
Okay.
I am fit emotionally, physically, and
Okay.
thanks.
Thanks. Right. For record purposes, Brigadier, do you swear that the further evidence you're going to give will also be the truth and nothing else but the truth? Okay.
Uthi usazokhuluma iqiniso uBrigadier uyaqhubeka kusukela lapho khona.
Yes, Mr. Mngomezulu.
Court business, my lord. Mr. Gininda, on the last occasion, I was asking about the J50s, the warrants of arrest. Do you still remember that?
Yes, I do remember that you spoke about the warrant of arrest of accused 1 and 2.
Usakhumbula uMnumzana Gininda ukuthi bekukhulunywa ngephepha eligunyaza ukuboshwa umangalo lokuqala nowesibini.
Just want to establish, are you aware that that application is governed by Section 43 of the Criminal Procedure Act?
Yes, the application for the J50 warrants, I am aware.
Uthi uyazi ukuthi umthethosekelo owabekwa lapho uyilo ukuthi wakhishwa ogunyazayo ukuthi abamangalelwa bangakhishelwa lezo incwadi uyazi ngawo.
Was the applicant brought by yourself or by the state prosecutor.
I've explained, my lord, that there was an indictment. After the indictment, I then made an application in terms of a sworn affidavit to the Boksburg Magistrate Court based on the indictment by the North Gauteng EPP.
Chazile ukuthi kwakukade kunencwadi eyikuthi bekade iphuma kuba umphathi wabashushisi yena ke wayenza i-affidavit.
This affidavit was, it's common, it's clear that it is in support of the application for the warrants of arrest.
It is for the application for J50 this month for accused 1 up to 5.
I-affidavit leyo bekade vele ihambiselana nalezo incwadi ezigunyazwa ukuboshwa bonke abamangalelwa kusukela kokuqala kuya kowesihlanu.
So it is your evidence that all 5 accused before this honorable court were arrested on the strength of the warrant of arrest.
Yes, it is.
Bonke abamangalelwa bona baboshwa ngenxa yokuthi bekade kukhishwe leyo ncwadi egunyazayo ukuthi baboshwe.
When looking at the provisions of section 43, it relates to an application to be brought before a magistrate. And such application is to be brought before the magistrate at which the alleged offense was committed. Do you agree?
I do agree, my lord.
Yavuma ukuthi incwadi lezo zona ezigunyazayo kwamele zikhishwe la ukuthi kusendaweni noma esivininini sala icala lenzakele ngakhona.
So in this case, 636 of 10/2014, it's common cause that it occurred in Foslorus.
Yes,
Correct.
it is. That is correct, my lord.
Iqiniso ukuthi lelicala le 636 10 of 2014 lona liyenzakele eFoslorus.
And we also have courts in Foslorus.
Yes, we do. But Boksburg, my lord, is a
I'm sorry, sir.
Oh.
Can I please? We are not in a lecture room. Follow my question, because there are technical issues that I'm coming to raise here. I'm saying it's common cause that this alleged offense or this offense was committed in Foslorus. Is that so?
My lord, I've agreed with that, but it will be trying to mislead this court to try and create an impression that Boksburg does not fall within the jurisdiction of Foslorus. That's what I wanted to clarify, and I think Mr. Mngomezulu knows that. Boksburg, Foslorus is a district court. In Boksburg, you get the regional court. Within the district of that area, it's one district, my lord. So there's nothing peculiar or unlawful that was done there.
Kuthi-ke ummeli lelicala leli kuyazeka ukuthi liyenzakele eFoslorus futhi eFoslorus kuney'nkantolo.
I'm going to
Mayichaza-ke ubrigadier uthi yena yebo zikhona kodwa nkosi enkantolo ngicela uchaze ukucacisa lana ukuthi eFoslorus kuney'nkantolo ezingaphansi ama-district court bese iBoksburg nayo iwela khona ngale ngaseFoslorus kula uthola-ke ama-regional courts.
do you know the rules relating to demarcation
My
in
lord,
terms of jurisdictions?
That's a good place, my lord. We don't want to interfere with my learned friend's cross-examination, but we don't see the relevance of this question, Lord. The issue of demarcation of jurisdiction has got absolutely nothing to do with this witness.
Yes, Mr. Mngomezulu, where are you going to?
I'm going to the place where this application was brought.
But we are in the High Court.
I beg your pardon.
Unless you want to submit that this case was unlawfully transferred from the regional court to the High Court.
That's not
pursuant to section 72, 72C, if you want to allege that. But now we are in the High Court.
No, I'm not
Oh, I see.
I'm
Okay,
not
fine.
relating to that. The sequence of my question relates with section 43, and it must be understood by these accused persons that are before this honorable court to say when I'm dealing with the issue of jurisdiction, I'll just demonstrate to the court that this application has been brought before a wrong court.
Okay, fine. What's your view?
I disagree, my lord. It's the same jurisdiction. I think the understanding of Mr. Mngomezulu is absolutely wrong.
Okay.
Mnumzana Mngomezulu uthi bekafuna ukubonisa ukuthi lesi sicelo besifakwe endaweni ekungasiyona uthi ubrigadier uyala uthi yena akaboni ukuthi bekafake lesi sicelo endaweni ekungasiyona.
I'll leave that for argument, but still maintain that Foslorus Court, the magistrate of Foslorus Court, as per section 43, directing that this person should be brought before a lower court. It was referring to Foslorus Court where the offense was committed.
It's the same jurisdiction, my lord. That's the point that I'm saying. That's why the SPP in Boksburg also is the same SPP for Foslorus District Court. There's one SPP, including the control prosecutor. So it's one and the same, my lord.
Uthi-ke manje mina ngiyafuna ukukwazisa ukuthi wena lesi sicelo usifake endaweni ekungasiyona ngoba bekwamele icala njengoba lenzakele eFoslorus bekwamele abamangalelwa bayobulisa umantshi ngale eFoslorus uthi indawo efanayo ngoba umphathi ophethe abashushisi owase-Boksburg uyena ophethe abaphathi abashushisi baseFoslorus manje ukuya ngayo ubrigadier uthi indawo efanayo.
I'm glad I have authority to the proposition that I've just put it to you, which I'll reserve it for argument. May I proceed? Let's get into the requirement that a peace officer or the commissioned officer who is to execute the warrant, when bringing this application, must have a reasonable suspicion that a particular offense has been committed. Are you aware of that?
Yes, I'm aware. This is the application now for the warrant of arrest, the J50.
I'm talking about the warrant of arrest.
Yes.
J50,
Yes.
section 43.
Yes.
Uthi uyazi nawo ukuthi umuntu womthetho uma yena unyaza ukuboshwa komuntu kwamele kube nokusola okuthize ukuthi kunecala elithize elenzakela uthi yebo ngiyazi.
And in terms of your evidence, you brought this application in October 2020, correct?
23 of October 2020, that's correct, my lord.
Uthi ukuya ngobufakazi bakho wena uthe le sicelo usifake ngo-October 2020 uthi yebo nge-23 zika-October 2020.
And I'm referring to all 5 accused were already in custody when you brought this application, correct?
Yeah, but my lord, I think we dealt with this aspect. I think it must be clear that they were in custody for different matters. To try and create an impression that they were in custody for this matter.
Mr. Gininda, with due respect, I'm not creating any impression. I'm cross-examining you on what is prescribed by the law. I'm not giving my opinion here. What I'm saying is, when you approach the court, Boksburg Court, on the 23rd of October 2023, I didn't want to know the reason as to why were they arrested, who was arrested first. I was saying all 5 accused were already arrested, they were in custody. Is that so?
For different matters, yes, my lord.
Uthi manje uyavumelana nami ukuthi ngalesikhathi ufaka lesicelo nge-23 zika-October 2020 bonke abamangalelwa akunandaba ukuthi bekade beboshelweni kodwa bonke abamangalelwa bona bebakade beboshiwe uthi yebo bebaboshiwe kodwa baboshelwa amacala angafani kungasiyile lecala.
Correct. The application that you brought on the 23rd of October 2020, if you understand what is a warrant of arrest, it talks about depriving somebody of his liberty. Do you agree?
My lord,
As a court case, my lord, we just want to the insinuation that if a brigadier knows something about a warrant, I think that we find that belittling and should be withdrawn.
No, I differ with my colleague. Brigadier Gininda is a very experienced police officer. The reason why I ask about Section 43, you can't do things because you have done it and you don't do it according to what the law prescribes.
So
If I'm talking, my lord, may I address it further before you?
Oh, okay, fine. Fine.
With due respect.
No, it's okay.
When this application was brought, if the brigadier was at that time able to distinguish between how warrants are issued and to him, when he brought this application, he was fully aware, because this is what the provisions of Section 43 and the case law requires, that he must exercise an independent opinion. Hence, his capabilities are expected when bringing this application. I cannot bring bail application not knowing what are the tests for bail application, what are the reasons for the refusal of bail, or what would be the reasons for granting bail. My submission is that in terms of what is required by this provision, especially case law, in Maposa's case, it reiterates the aspect of an independent opinion to be exercised by who? By the commission officer who's executing a warrant of arrest in terms of Section 44 of the Criminal Procedure Act. He must answer questions relating to this application that he brought for the arrest of these people.
Yeah, but I'm not interfering. Mr. Brigadier Gininda says you and him have a different conceptual understanding of Section 43. Is that correct?
that's correct, my lord.
Let's read Section 43.
Thank you.
Because he says we don't have the understanding which he has.
Let's read. Can you
So
read it for
who's
me?
got Section 43?
manje ke uma kuchazwa kuthiwa ingathi ummeli nobrigadier banokuzwisisa okuhlukile ngaleyo mthethosekelo okukhulunywa ngawo waka 43 oyikuthi
There's no subsection you want. You just want Section 43, sir.
uya ngobrigadier yena uwazi kanje
Hello?
Subsection one.
Mngomezulu uwazi kanje
Section 43, subsection 1.
Correct.
Mr. Counsel is going to read it out.
Not me.
I'll read it out. The heading is warrant of arrest may be issued by magistrate or justice. Subsection 1 of Section 43. Any magistrate or justice may issue a warrant for the arrest of any person upon the written application of an Attorney General, now Director of Public Prosecutions, a public prosecutor or commissioned officer of police, then subsection A, which sets out the offense alleged to have been committed, subsection B, which alleges that such offense was committed within the area of jurisdiction of such magistrate, or in the case of a justice, within the area of jurisdiction of the magistrate within whose district or area application is made to the justice for such warrant, or where such offense was not committed within such area of jurisdiction, which alleges that the person in respect of whom the application is made is known or is on reasonable grounds suspected to be within such area of jurisdiction, and subsection C, which state that from information taken upon oath, there is a reasonable suspicion that the person in respect of whom the warrant is applied for has committed the alleged offense. Subsection 1 in capital A. Notwithstanding any other law, an application for a warrant under this section in respect of the offenses listed in section 21 in brackets 1A, A to D, may be made to any magistrate or justice, irrespective of whether or not the place of execution of the warrant or the place where the alleged crime has been committed falls within the jurisdiction of such a magistrate or justice. Subsection 2. A warrant of arrest issued under this section shall direct that the person described in the warrant shall be arrested by a peace officer in respect of the offense set out in the warrant, and that he be brought before a lower court in accordance with the provisions of section 50. And lastly, subsection 3. A warrant of arrest may be issued on any day and shall remain in force until it is cancelled by the person who issued it, or if such a person is not available, by any person with like authority, or until it is executed.
Thank you. Now, what is the problem?
The question from the court, I just want to get it clear. If does it relate, the question of the court, does it relate
Now it relates
to the
both-
difference between
It relates to both of you.
To
Because
both of
me
us.
listening to this section being read, there is no problem. It's clear as water. What should happen?
it is clear?
So what are you saying Brigadier Gininda did not do in pursuance of section 43, subsection 1? What
Yeah.
did he not do?
All
So
right.
that we all know the
Okay.
dispute.
If I'm understood very well,
Yeah.
because I'm trying to run away from the fact that a witness will say, I'm creating an impression. Let's just put it straight and clear forward. Warrant of arrest, it deals with somebody who is not in custody.
No, that's not how I understand the law. I kill somebody today, and Inspector Nisi arrests me and puts me in custody because he's got evidence that I've killed somebody. After 3 weeks, Inspector Nisi hears that, he killed another one in Klipspruit. I'm inside. He goes and effects a warrant of arrest in respect of that other one. What's the problem?
My Lord, I'll differ with the court.
Okay,
I'll
fine.
differ with the court. I'll make submissions as well.
Okay.
Because there is also a procedure in relation to the requisitioning of a particular suspect or an accused person. Yes. Hence, a scenario in terms of what the court is now making, it's relating to it actually goes to the meaning of what is arrest. It will actually go to the meaning of what is arrest, because the logic on this application, because there's somewhere in this provision that says a person is reasonably suspected to be residing somewhere, if I'm not mistaken. But when an application is brought by an officer who is fully aware that this person is not in Tembisa, this person is Modapi, it's clearly misrepresentation of facts, because if you look at the J50 that we talk about, it does not bear the date, the address in which the suspect is at the time of the application was brought. That's the reason why I'm
So you're
saying.
saying Brigadier Gininda didn't specify where the suspect,
That's correct.
that they are in Moda B, as you say.
That's correct.
Sir, what specificity did you annotate on the warrant?
My Lord, insofar as accused 1 and 2, well, let me start with 1, my Lord.
Yeah.
I've said address unknown based on the events that had unfolded that time.
Okay.
And I've explained that in my evidence in chief and during the cross-examination last year, my Lord, in the issues of the address and the bail application, my Lord.
Manje ke kule ncwadi egunyaza ukuboshwa kwabantu uthi ke wena inkosi yenkantolo yabuza ukuthi uye wabhala yiphi address ke yakamangalo oqala uthi ngiye ngabhala ukuthi address angiyazi njengoba bese sengichazile konyakenye uma singiphana ngobufakazi bami futhi ngabuzwa nemibuzo nakhona ngachaza nalokho.
Yes.
And I'm not sure, my Lord, whether Mr. Mngomezulu is insinuating that a prison is a residential address, because it's clearly asked on the J50 application, on the warrant, address, which is a residential address. You can't now put a building, correctional services as a residential address. I've never seen that.
Manje ke anginaso isiqiniseko sokuthi mhlawumbe umnumzana Mngomezulu uchaza ukuthi ijele yindawo ukuthi mhlawumbe ingasetshenziswa njengekheli, ngoba mina angiboni ukuthi ngingabhala ikheli ngithi lo muntu usejele usekaboshiwe ngalesikhathi ngifaka lesi sicelo leso.
Mr. Gininda, you don't even understand yourself. Listen to this. On the 30th of May 2020, first time we met SB in Vosloorus. You allege that he made a confession. That's your evidence. Immediately, spontaneously, you look for somebody who can take a confession. And you knew at that time where was Sibiya kept.
But that's not correct, my Lord. On the 30th, that was the first time accused number 1 was arrested insofar as the drug dealing matter. So that was the first time he was arrested. It was before he was even incarcerated officially, in other words, being detained in the holding cells.
Uthi ke manje mina ngithi kuwe ubaba Mngomezulu uthi kuye nge-30 zika May uma uhlangana nomangalelwa uSibiya wena uhlangene naye eVosloorus bese uthi uye wafuna ukuyozigunyulula la ukuthi uye wafuna umuntu bese ke kwagcina seyikuthi umangalelwa usekayokhuluma nje kanjalo uthi cha mina ngithi umangalelwa nge-30 ngalesikhathi bengiqala ukuhlangana naye ezoboshelwa leliyacala lokuleyidakamizwa akusukuthi umangalelwa ngaleso sikhathi bese sekaboshiwe.
And my Lord, the issue of getting, as Mr. Counsel is suggesting that I've made arrangement for spontaneously for someone to obtain this confession, that's the best practice. You try and get someone independent to document the confession. It is done that way, so that there's no issues of compromise or having interest in the matter. That's how it's done. There was nothing spontaneous about it.
Futhi njengoba ukhuluma nangokuthi ngiye ngathola umuntu ngaso leso sikhathi uthi vele into ekwamele yenziwe ngoba wena usuyazi ngecala kwamele uthole umuntu ongenalo ulwazi ngalelo cala oyikuthi uzokwazi ukuthi athathe i-statement salomuntu ofuna ukuyokhuluma.
I don't want to rush you and you don't want to rush me. I'll get into that aspect of the procedure of how to take a confession. But my concern is when you met Sibiya for the first time, you questioned him to the extent of explaining his constitutional rights relating to this case. I'm not talking about drugs cases here. I'm talking about the murder of Senzo Meyiwa. You allege that he made a statement and immediately you took a decision that this person is confessing. Let me do the formalities. My concern is when Sibiya was already arrested on a J50 by Sergeant Mkhula, he was already under arrest.
I don't understand what is the question, my lord.
Let me repeat it for you, because you tend to explain things that you don't even understand yourself. The question is, when Sibia was arrested on a J50 warrant of arrest applied for by Sergeant Muhula, when he was brought to you on the 30th of May at Vosloorus, he was already under arrest.
My lord,
That is a good case, my lord. I think the counsel owes the witness courtesy in cross-examining him to say that he explained things that he doesn't understand. I think it's simply rude, overbearing, and we submit that part should be withdrawn.
Yes, Mr. Mngomezulu, let's hear you.
It's I would say, I'm glad if my colleague can pick up that. But if that is done by this witness, I'll make an example of what he's saying. Mistakenly, I've uttered words and said, you read the rights of the accused. Out of insinuation, he said, no, I didn't say that. I understand what I was saying, and he better understood what I was saying. He said, no, I said I explained the rights, not I read the rights. So I'll take him according to the attitude he wants to address me on. But as long as he's going to maintain the decorum of this court. The question that I'm still maintaining is, I'm going to establish and prove before this honorable court that when this application was brought on the 23rd of October, when it was brought, it was unlawfully granted or unlawfully obtained on the 23rd, because this accused person was already in prison. What is of pivotal importance is here, what do you submit as facts to the magistrate who's going to grant or issue that warrant? If the address appears to be unknown, obviously in the mind of the presiding officer will say it must be circulated for this person to be arrested. Then what to go to section, I'm trying to explain this so that we are in the same picture, Your Worship, my Lord.
You are not with this witness.
No, in terms of the law. But with this
He
witness,
also
that's
says
why I'm...
he also says in terms of the law, you are not in the same picture. Am I correct, sir?
Absolutely, that's what I'm saying.
That's how I understand
Yes,
it.
section...
What, Mr. Mngomezulu? Otherwise, we're going to be here until Mandela is resurrected. Why don't you put your version of what you are arguing the law is going to say and let this witness respond to that?
My Lord, I'll do that.
Because now you're putting a version,
I'll do
or
that.
a snippet of a version, and he says to you, no,
I'll do
I
that.
didn't know where his address is, because I remember you saying you guys went down to go and check Nongoma, and
Correct.
he was not known there.
Correct.
I
It
mean,
was known,
but
but he comes
You
from
see,
visits,
my Lord, look at this. Look at this. Look at this. That's why at some stage when I address the court, it will be like I appear to be sarcastic. No, my Lord, the evidence of supporting this witness, to say he went to the extent of looking for this witness, the witness that was already incarcerated, it's a redundant application, especially for section 43.
No, it's not.
I'll submit
Because he
it.
says they were going to check his residential address.
Correct, ma'am.
That's what the law says.
For what?
You arrest a person, no, Mr. Mngomezulu, please, otherwise you're going to be here.
My
You
Lord.
arrest, oh, no, wait, let me tell you my experience. You arrest a person, and then he wants to bring a bail application. He's inside the cells in jail.
Yes.
And then the state says we are opposing the application for bail because we want to ascertain the residential address of this accused. Is that not
Yes.
so?
It is so, ma'am.
And then you
That's-
leave them in the cells, you go to Nongoma. That's
It's-
what he says.
that's
And
a
he says when
different-
he got to Nongoma, he went to a particular address furnished by the very witness.
He was actually with us, my lord.
Oh,
I
he-
booked him out and I drove with him.
And then they
to
said, we
Guantanamo.
don't know this man.
They said they know him, my lord, but he comes on regular
Oh, I see. Fine.
visits.
It's even worse. The applications are not the same.
Okay, what else,
Application for
Mr.
bail
Mngomezulu?
application is not the same as the warrant. A warrant of arrest, my lord, let us be honest. Section 40, which deals with the warrants with or without a, that's when you deprive a person his freedom. Literally, that means you deprive the person
If he
his
has
freedom.
transgressed the law.
That's correct.
If he has not transgressed the law, you deprive him of his freedom. You're right.
Yes, you can deprive him even if there are allegations that cannot be founded at a later stage.
fine.
Once they withdraw charges or he gets acquitted
Okay.
or whatever.
So
But
what else do you want to put to this witness?
you know, the reason why I had to deal much on Section 43, I want to make fruitful, I'll put it that way, fruitful submission during my argument.
Okay, fine. Are you through now with
Accused
Section
number
43.
1 and number 2 were already arrested. And my lord, I don't want to remind the court about the attitude of the court towards the defense and the attitude of the court towards the witness, because that will also constitute unfair trial.
what's the attitude now?
No, even that, I don't want to go back to the records, my lord. I'm just checking when the witnesses are testifying, what is the attitude of the court. May I request the court to remain impartial? May I
I'm
request, if the
impartial.
court, sorry, my lord.
I'm impartial. The only thing I'm doing in this court, I'm quoting the law as I understand it.
I've indicated
That's
earlier
all.
on. I've indicated earlier on when I was cross-examining Mhola. I said after the examination of Gininda, I'm going to bring an application under Section 371 to make it
317.
317, a
Yes, I
special
know the law.
entry.
317.
Yes, a special entry
Yes.
because of what I've picked up during.
Okay, no problem. You're
Yes.
at liberty to do that.
Hence, I'm saying my problem is with the application. Let me just put it this way. When you were, after Sibia and Danzi, after Sibia and Danzi were charged for the Senzo Meyiwa case, there were so many rights that were explained in relation to 636 during their arrest. You remember?
My lord, I remember, but I would like to start on the aspect that the state advocate objected on. I think, with utmost respect, I don't believe I've treated Mr. Mngomezulu with disrespect. The fact that I differ with him with regard to the version that he's putting based on the evidence that I have in court, I mean in the docket, is not a sign of disrespect. But I've never spoken to him with any disrespect, and I would like him to treat me the same. I'm here to assist the court. I will answer him insofar as the question that he wants to know, and there's no reason to get emotional on this. Let's just do the business of the day, be professional about it, and move on. That's all that I want to ask him.
Brigadier uthi-ke ithi ngiqale la ubaba uBaloyi uye wasukuma ethi kunento afuna ukuyiveza, uthi ngithanda ukuveza lana nami ukuthi angisukuthi umnumzana uMngomezulu angimhloniphi, ngiyamhlonipha nanoma ngiphendula ngimphendula ngenhlonipho, njengoba naye sekachaze ukuthi ubona ingathi angikhulumi naye ngokumhlonipha. Uthi cha, lokho akukho njalo. Mina ngicela ukuthi sibe la sixoxe lolu daba olusilethe la, siyenze ukuthi lelicala leliqhubeke, sikwazi ukuthi sisize inkantolo, sisebenzisane ngokuhloniphana. Uthi ngiyamhlonipha naye akangihloniphe, sihloniphane sihloniphe inkantolo.
I will refrain from such a conduct as long as we are in the same path. And this is not a condition. I'm just saying it, and I withdraw if I offended you. But let us take each and every question and answer in a way that will assist this court to see if such confessions were taken properly.
Yes, I agree, my lord, but in answering that, I cannot agree to things that I see are intending to create a wrong impression to the court. That's what I'm here for. And if I point those things out, Mr. Mngomezulu must understand that I'm simply here to assist the court. There's nothing personal about it. I'm raising what I'm raising based on the investigation that I've conducted. It's nothing personal. And if you want to challenge me with that and point me to another direction, if of course the facts are there, I'll concede. But if the facts are not there, I can't concede to something that is wrong. But that is not meant as a sign of disrespect. It's what we are here. We are here for that, my lord.
Mnumzane Mngomezulu ke uthi ngizoyeka ke lokho njengoba uthi sihloniphane, ngizoyeka ukuthi singahloniphane, sizohloniphana, kodwa uma ingabe mina nawe sizovumelana kwizinto ekuthi ngiyazibuza, ubrigadier uma iphendula uthi yebo asihloniphane, nami ngizoyenza ukuthi ngiphendule imibuzo ngalendlela uyibuza ngakhona, kodwa uma ingabe ikhona indawo ekuthi ufuna ukungisa kuyona ekuthi mina angivumelani nayo, ngeke ngivume, ngizoyenza umsebenzi ukuthi mina bengikade ngiphenya kuleli cala futhi ngisize inkantolo ukuthi inkantolo ibe nesinqumo ekuthi yasithatha. Angizanga la ukuthi ngizothatha izinto ngenhliziyo, asebenzisane ungibuze ngiphendule bese sikwazi ukuthi leli cala siqhubekele phambili.
Now, my lord, I'll come to the last question, but the first, perhaps maybe let me try and deal with what I remember what Mr. Mngomezulu raised, my lord. The issue of the J50s, and this is my understanding, that's why I said him and I have a different opinion. We've now read section 43, I think it's clear as daylight. But secondly, the warrant of arrest or the J50 is a means of taking someone to court. It must not be construed as the violation of the rights of the person that has been arrested. In any event, the Constitution, my lord, section 36 has a limitation clause. Once this case is made and the warrant is authorized, what do? The person must appear in court. And the warrant of arrest is the means of taking the person to court, as it can be summons, any other thing. I'm not aware of any provision in section 43 that says if a person is in custody, you cannot execute a warrant. I'm not aware of that. It was a means that was before us. The case that they were facing, my lord, is premeditated murder. I mean, even if the person was outside, how do you go and warn a person outside to say you've killed the person X on this day, you must go and appear on your own? There's no way it will amount to J50, my lord.
Uthike ithi mchazele indaba le yamaphepha agunyazayo ukuboshwa kwabantu, mina angiboni ukuthi lamaphepha lawa ayewakhishwa ngendlela engekho emthethweni, ngoba mina umuntu nanoma engaphakathi kodwa njengoba ebhekene necala elibucayi ukufana nalo leli cala lokuthi uye wahlala phansi wacabanga ngokuyobulala umuntu othize, mina ngokwami ngiyazibuza ukuthi ke uya kanjani kumuntu nanoma engaphandle ufike uthi kuye ubhekane necala lokuthi wena uye wacabanga ukuthi uyobulala umuntu bese ngelanga elithize uye enkantolo. Ngoba isizathu sale ncwadi le egunyazayo ukuthi umuntu aboshwe ukuthi lo muntu loyo ube nalelo phepha bese uyaya uyombopha, akusukuthi uye uyomcebisa ukuthi ngelanga elithize kwamele uye enkantolo. Uthi manje lokho yiko engifuna ukuchaza ngalo lemcala.
Lastly, my lord, on the last part that Mr. Mngomezulu asked me, my lord, yes, they were right that were explained prior to the execution of the J50s on accused 1 and 2. Insofar as the questioning that took place prior to the arrest, they were questioned at a certain stage on the 30th, and whenever we engage with them, constitutional rights as prescribed and required to do so were explained to them. But insofar as the arrest, my lord, that took place, in other words, the indictment of them and the charging formally of this matter on the 26th, that was explained in terms of 14A, as also prescribed, my lord.
Manje ke ithi ngiphendule lo mbuzo lo bengibuzwe ngawo uthi yebo amalungelo wona akhona ayikuthi ayewachaziselwa umangalelwa maningi, kodwa ngaleli cala kuye kwafanele ukuthi simchazisele futhi amalungelo, ngoba lawayana bekwamalungelo welinye icala ngalesikhathi ezokhuluma futhi kube kwamele ukuthi simbuze simchazisela amalungelo wakhe ngaleli cala, njengoba na kuleli cala bekwamele siyenze ukuthi sithole le phepha egunyaza ukuthi aboshwe bese siyambopha ke, ingakho bekwamele simchazisele amalungelo wakhe.
Okay. You gave your own understanding of section 43. My question now is, in your affidavit, did you ever mention that accused number 1 or number 2 was arrested for another offense? Did you mention that in your affidavit? I
beg your pardon, just what is the question, my lord?
My question is, when you brought your application, it was supported by an affidavit.
Yes.
In that affidavit, did you state clearly that accused number 1 and number 2 are in custody or were arrested?
I'm not sure, my lord. I'll have to refresh my memory. I mean, I've made that application in 2020. The important thing, the background of the case that was stated, I know that the evidence insofar as accused 1 and 2 that I was making the application on, I'm sure I've stated that. But as to where they are or where they were at the time, one will have to refresh, my lord. But the defense has also the copy, and I've got, I can go through it if that's what they want, my lord.
Uye wabhala na kwi-affidavit yakho ukuthi abamangalelwa ngaleso sikhathi bebakade bebuphi noma bebakade beboshiwe, uthi anginaso isiqiniseko kodwa ngiyacabanga ukuthi ngichazile kule affidavit yami ngoba ukuthi ngiye ngasho na ukuthi baboshiwe noma cha, lokho kuzofuneka ukuthi ngiye mhlawumbe ngifunde statement sami futhi kodwa unaso ummeli nami nginaso, uma engabe kuyavumeleka ngahle ngibheke bese ngiyakwazi ukuthi ngiphendule yebo noma cha.
And last, my lord, the application was not about the verification of address. So I just want to say this. It was about the J50. It was not a statement to say whether the address is positive or negative or they're staying there, So they might be there in terms of the background of where they are. But even if it's not there, my lord, that was not the essence of the application. It was the evidence that I had and the request for the J50 authorization.
Futhi ke leso sicelo bekungasi isicelo sokuthi siyavumelana noma asivume ukuthi ikheli labamangalelwa yilona noma akusilona, bekuyisicelo esigunyazayo ukuthi sithole igunya lokuthi siyobopha abamangalelwa. Yiyo into emsemqoka ebengifuna ukuyichaza.
Let me just put it to you by saying, if that is the statement you made under oath in a 198 statement, if that is the application, that's the statement or affidavit in support of an application, I'll ask you to go through that statement. But in the meantime, I just want to put something to you, then you can comment on that one. If you brought an application, that's what I'm putting to you as a matter of law. If you bring this application and state clearly in your affidavit that accused number 1 was in Moda B and accused number 2 was at Pukeng police station, I'm making an example. The court, the magistrate court, was not going to grant that application. Do you agree?
No, I don't agree because you are now, I don't know, I don't agree, my lord.
Uyavuma na ukuthi ngalesikhathi wenza le sicelo lesi sale ncwadi egunyazayo ukuthi abamangalelwa beboshwe kube uye wachaza ukuthi umangalelo oqala mhlawumbe umzekelo use Moda B, umangalelo wesibini yena mhlawumbe use Pukeng police station, ngaleso sikhathi leso sicelo besingeke sivunywe uthi cha lokho ngiyaphika.
Perhaps counsel, my lord can refer me to a section that says if a person is incarcerated, a J50 warrant cannot be issued. Then perhaps we can close this matter because I'm not aware of such.
Mhlawumbe ke uma ummeli angangibonisa umthetho othi uma engabe umuntu eselaboshiwe akwamelanga ukukhishwe incwadi egunyazayo ukuthi lo muntu angaboshwa kwelinye icala, mhlawumbe singakwazi ukuthi sivumelane noma siqhubekele phambili.
Yes, it's fine. You can say that or you can ask for that law, but I'm still putting to you that the proper way of securing the attendance of these accused persons who were at that time of the application were in custody was to requisition those accused to the relevant court for their first appearance. Do you agree?
As a please, my lord, that question is unfair and it's wrong. The witness has...
But they haven't appeared in court anyway.
Yes.
How do you requisition?
Yes.
As I understand the law.
Yes. In any case, the witness has already said that a warrant is a way of securing the attendance of a person in court. And Section 38 clearly states, my lord, that the method of securing the attendance of an accused for his or her trial shall be arrest, summons, written notice and indictment in accordance with the relevant provisions of this Act.
That's the only way.
The question that my learned friend is putting to the witness is
So that's Section
incorrect.
38, sir.
Yes, Section
It
38.
doesn't talk about requisition. Hello? Does it
Yes.
talk about,
No, it doesn't talk about
does it talk about requisition?
No.
Okay.
We will,
It talks about a summons.
Yes, someone's fine. Section 72(5)(c), I think. Hello?
I was listening to
No,
the
I'm
court.
quoting the law.
I
When you-
didn't hear what the court was saying.
No, you know the law. I was saying to the gentleman who's saying he talks about a summons. There's a way it deals with what a summons is.
Yes.
Yeah, fine.
Mark, I'll still maintain, I'll get into the part where, even if you say there's no such a law, my concern is when the application was brought, there was an information that was not disclosed fully to the presiding officer.
My Lord, the address, how is it relevant to the evidence? What the presiding officer and the prosecutor, who obviously both of them signed the warrant, needed to know the strength of the case, whether such warrant can be authorized. And the decision was taken based on that, and as well as the indictment that I referred to. So the issue of address, like I've said, my Lord, if counsel perhaps can say to me, this is a section that says you cannot get warrant of arrest or warrant signed by the magistrate when a person is in prison are unlawful, then we'll find each other. Because like I'm saying, I'm not aware of such, my Lord, and there's no law that says that. And secondly, lastly, my Lord, as I've said earlier, warrants of arrest are one of the means to bring people to court.
Uthi-ke manje mina ngiyakutshela ukuthi ngalesikhathi wenza lesi sicelo kunezinye izinto ongazivezanga kuleya ncwadi egunyaza ukubopha umuntu. Uthi anginaso isiqiniseko sokuthi ukhuluma ngani ngoba ngiyacabanga mina ukuthi lencwadi egunyazayo ukuthi umuntu aboshwe incwadi ezoyenza ukuthi lo muntu sikwazi ukuthi ayovela nasenkantolo. Uma ingabe mhlawumbe ungangibonisa umthetho oshoyo, mhlawumbe singakwazi ukuthi sikhulume into efanayo, kodwa okwamanje mina ngisamile ekutheni incwadi leyana ngiyifake ngendlela esemthethweni, ingakho iye yavunyelwa nayo inkosi yenkantolo.
The J50 warrant of arrest, I'll just pass the issue of address, but it is relevant, and I'm going to make submissions on that irregularity in terms of granting or issuing that warrant of arrest. Now let's get into your statement. I think it's A198, if I'm not mistaken. Your affidavit. Are you in possession of that, sir?
For the application for the J50 warrants?
Yes.
No, I'm not, my Lord. I'm not, my Lord. But my Lord, to say the application, the issue was irregular, I disagree. There's no
That's
such.
for the court
I
to decide,
disagree.
my Lord.
No, it's not for this court to decide. It's for
Yes.
you, Mr.
Yes, I'll make
Mr.
submissions. At the end of the
Mngomezulu, to
day,
bring an application reviewing the decision of that magistrate to say that when he granted that warrant on application by Brigadier Gininda, the law was not permissible for him to do that. Not the witness himself. Unless you accuse him of fraud, fine. Fine.
are you in possession of that?
Yes, I am.
Am I correct to say it's A198?
Yes, 198, that's correct, my Lord.
Do you need some time maybe to check if the aspect of the address has been canvassed on that affidavit?
I can, my Lord, but like I said, I can. If the
Yes.
defense wants me to do that, but I've already dealt with the matter.
Now, I
The
just want to
issue-
place it on record, Mr. Gininda.
I will, yes, my
Yes.
Lord. But what I'm saying, what must be clear, there is nowhere where the issue of address is a prerequisite for getting a J50. You don't get J50 unless you are saying the person Because even if the address is wrong, if the elements of a crime are not there and the person didn't commit that offense, why would the judiciary sign the warrant of arrest? The basis of this application and authorization was based on the evidence collected insofar as accused 1 and 2 are concerned, my lord. But I will check if
No, this court wants to know what's inside that warrant.
Usiphethe na
That
istatement sakho.
application, the court must also know.
Usiphethe istatement sakho uthi yebo ngisiphethe uthi ungasibonisa la ukhulume khona ngekheli likamangalelwa uthi lokho ngingakwenza kodwa angiboni ukuthi kumqoka kanjani ngoba awukho umthetho ongivimbayo ukuthi uma ngingenalo ikheli likamangalelwa ngingahle ngifake lesicelo. Manje mina ngibona ukuthi lesicelo ngasifaka ngendlela esemthethweni uthi ngakwenza lokho na njengoba seka sibheka istatement sakhe efuna leyo ndawo la ikuthi kubhalwe khona.
But you're going to read that statement, sir? Were you suggesting the same, Mr. Baloyi?
No, I want to point out that my learned friend wants to use a statement that he hasn't proven as yet. He must first prove the statement, then follow
No,
the
it's okay. He doesn't have to prove it if he wants this witness to read it under cross-examination. Okay. That's the law.
Well, we still maintain that if you want to cross-examine on a statement, you first have to prove it.
No, fine, but not under these circumstances because they're not at either. Just read that for everybody to know what is in that document.
All right, my lord. So it says, I, the undersigned, Bongani Nicholas Gininda, state under oath, as follows in English. I am employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same act. I am currently stationed at the National Commissioner's Office as the commander for Cold Case Investigation Unit of the National Commissioner, with the rank of a colonel and the service number. I've mentioned the service number as well as the telephone number. That's paragraph 1, my lord.
Now you get
No.
paragraph
Let him finish first.
as the court places. Thank you, my lord.
I am the lead investigating officer of Phosphorus 636-10-2014, which is a case of murder where one Senzo Meyiwa was shot and killed on the 26th of October 2014 between 20:30 and 2100 hours. It initially appeared that it was a robbery gone wrong. Witness statements under oath indicated that 2 black males entered the house demanding cell phones and money, purporting to be a house robbery. 7 adults and 1 child were present in the house when the accused entered. The witnesses stated that one of the accused was carrying a firearm, purporting to be a revolver. This accused was described as a black male with big eyes, dreadlocks, wearing a khaki or brown jacket or top and a hat. He was shorter in height than the second suspect. The second suspect was described as a tall, slender, neatly shaven and dark in complexion. It is stated under oath that during the robbery in the same house, a struggle ensued between Senzo Meyiwa, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect. One of the gunshots hit the deceased Meyiwa on close range in his chest and exited at the